is an extraordinary power, not to be taken lightly or to be exercised without considerable deliberation, intent, and purpose. We are on the record in the matter case D21. Please confirm your appearances.
Appearing in proper person.
Good morning.
Good morning, Your Honor. Shannon Wilson, bar number 9933, on behalf of appearing in a limited scope capacity. Before we begin this morning, Your Honor, this is Mr. motion for an order to show cause. However, we would like to motion the court to close the proceeding to the press and the public, or in the alternative, to exclude recording devices. May we begin with that argument?
Your Honor, I would obviously, I think I've been very clear on the record regarding transparency, accountability, and the First Amendment analysis, so I would object on those grounds. Also, this is, like she said, an it's a threshold matter for an OSC, which makes it a quasi-criminal matter. So I think that it would be somewhat odd for to not assert her Sixth Amendment right to a speedy and public trial. So I'm just calling attention to all of those issues, but request that the court narrowly tailor the issue pursuant to Falcone, Nestor, and the First Amendment analysis.
Anything you wanted to add?
Wow, oh so much, Your Honor. But I will keep it to the idea that Mr. thinks that he can transform his allegations of this alleged conduct in contravention of a divorce decree and parenting agreement into a quasi-criminal proceeding is a fundamental misunderstanding of Chapter 30. Leaving that aside, right, the fundamental question before this court today arises with respect to Ms. close the proceeding, arises under Falcone versus 8th Judicial District Court versus 8th Judicial District Court, which interpreted Falcone, and Supreme Court Rule 230 regarding electronic coverage of court proceedings, right? This court said in just February of this year in this matter that the privacy and psychological interests of the minor children that Ms. argued outweigh the compelling interests of the public and the press to open court proceedings. This court said was not sufficiently specific to rise to the level of closure of all of the proceedings in this case. And so the court said that what it would do at the time of trial was close the testimony of the custody evaluator and Child Protective Services. However, the thing that doesn't make sense about that is that these parties at the time of trial and here today are going to talk about the very same things that the custody evaluator and Child Protective Services are going to talk about. Now, we have, Ms. and through me, have attempted to articulate those privacy and psychological interests of the children. Can I sit down?
Yes, the parties may be seated.
We have attempted to articulate those interests by reference to the moving papers and the exhibits, which at least to this point in this case remain closed, so as not to let the proverbial cat out of the bag, so to speak. But if the court's finding that our reference to those things that are sealed does not rise to the level of a sufficiently specific articulation of an interest, then let us be a little more specific. Today, in the context of this very motion for order to show cause, what Mr. seeks to do is have his children's mother put in jail for upwards of 14 days for doing things like enrolling their children in extracurricular activities, for taking the children to medical appointments, of which she notified Mr. And for a supposed pattern of conduct. Now, those general things, you would say, well, gee, I don't see there any sufficient privacy or psychological interest that would necessarily adversely impact the children. I would argue that a dad's request to put a mom in jail probably does rise to that level. But additionally, within Mr. specific motion here, he alleges that the party's then 4-year-old daughter was subjected to invasive testing. Now, never mind that that is not actually what the medical records say happened at all, but that a child being tested with respect to her complaints most certainly rises to the level of a privacy and psychological interest of a minor child that outweighs the right of the press and the public to be present in proceedings where those things are going to be discussed. There are, of course, still other things, but that is hands down the most egregious one. We have not wanted to state with that level of specificity the things that justify the closure of these proceedings. But we have come here time and again with the request pointing to these allegations in the myriad moving papers, and the court has told us time and again that somehow that is not sufficient to justify the closure. If the court continues to state that that is somehow not sufficient to justify the closure, then we would additionally ask the court to once again stay these proceedings so that we can take that decision on yet another writ petition to the Nevada Supreme Court. Thank you.
All right, so here's what I'm inclined to do. And the matter before the court is narrowly tailored to the issue of contempt and the motion for contempt filed by the defendant. I do find, given the nature of the proceedings, and as I've prepared, which has included the review of a number of exhibits that both parties have submitted for the record, which primarily focus on text message exchanges between the parties, an element of the request regarding contempt does relate to a provision associated with the medical care and treatment of the children. And there are specific incidents that are highlighted as to contempt that's being sought by defendant against the plaintiff that relate to that specific provision and to care and treatment received by the parties' children, specifically by I do find that there is a sufficiently compelling reason as it relates to that specific issue and the medical care and treatment issue that's part of the post-decree order that was entered by the court, those aspects and that discussion by the court and any questions asked by the court related to that provision, I would narrowly tailor that exception that should be excluded, because I do find that it may delve into some very sensitive private issues that involve the children that should not be available for any type of public consumption. So, but I would limit and tailor the court's order, because this should be an open proceeding, generally speaking, but I would tailor our discussion in order that any discussion when I get into specifically that particular issue as to the medical care and treatment provision, and specifically the order from the October 4, 2023 hearing that was entered on October 17, 2023. So those discussions should not be recorded, should not be disseminated in any manner. Otherwise, I find that the matter should be open to the public, and I would not provide any additional limitations, and that would be my order. And I'm inclined to proceed. I don't know if there's a desire to pursue any type of writ relief, but at this point I intend to proceed with the matter based on those orders. Certainly it can be challenged, the other aspects, but I do want to swear both parties in. If you'll both please stand and raise your right hands to be sworn.
Do you solemnly swear or affirm the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
All right, you may be seated. This matter has been fairly well briefed by virtue of the papers that have been filed by both parties in proper person. And the plaintiff is appearing with the benefit of counsel, Ms. Wilson, in an unbundled capacity. So I've had a chance to review those papers. I've also taken the opportunity to review the text messages that were offered. I appreciate in going through that, there was some attempt to focus the court on specific communications between the parties. That is appreciated, but just so you're aware, I read through every text message that was submitted to the court in those exhibits. Because I didn't want to miss anything, but I do appreciate the efforts to try and focus the court on the relevant communications between the parties, and it's referenced that is just a thumbnail of the messages that have been exchanged between the parties over time. I also, generally, I start proceedings by asking if there are any stipulations or agreements. I'm somewhat presuming there are none, but I do want to at least offer that question. Any stipulations or agreements to place on the record?
There have not been, Your Honor, but may I briefly make a record as to the procedural posture of the case? And I do appreciate the court's willingness to narrowly tailor, but there is a matter that's tied to some of those issues that I would like to brief, just so the rest of this presentation makes sense.
What, in what regards?
There's been in regards to service issues and irregularities, there's been a lot of allegations to the extent that I'm being vexatious or somehow frivolous or harassing, and I need to brief the procedural posture of the case as far as these irregularities are concerned, which pop up in close proximity to substantive hearings. I'll be very brief.
Okay, you may do so.
Thank you. So recently, on the 28th of April 2025, plaintiff filed her opposition to my motion for an order for show cause. She did not serve me the 50-page exhibit appendix. She corrected it only after I notified her. That's documents 317 through 318. At the same time, she failed to serve her pro se opposition to close the court on the O and J, and that directly impugned their rights. On the 16th of May 2025, plaintiff's counsel filed an errata to her notices of limited scope, and this is an issue that's pending before the court on a separate issue. I'm not prepared to brief that, but it does highlight some issues. There was something going on with the address. She went back through the history of the case and changed her address a bunch of times. So the result is there's multiple documents now with this wandering baseline as to where she actually lives. So I highlighted that in my reply, and that prompted a second errata correcting the first errata that she filed just days later on the 19th of May 2025, changing them back. So that has bearing on unopposed motions under ACR 511A through B, where I'm sure the court, it impinges, or it has direct tie to if you were to issue an order and then me with knowledge of where she actually lives, if I didn't say anything and raise that issue, then it could form the basis of a set-aside. So the record reveals a recurring pattern here: untimely filings, erratic supplementations, service irregularities, and not just the exhibit appendix issue with me, which she did correct, but this is the posture of the case. And now with this address information, so I'm not making any assertions regarding her intent, but I'm just highlighting the operational consequence overall and how that's had an impact on me as a pro se party. I've been repeatedly placed in a reactive posture and having to cover down on whatever issues are going on that side, but that's professional counsel, and that lack of attention that's degrading her obligations. It's either tactical or it's not. And to the extent that there's been claims that I've been unnecessarily multiplying the proceedings, I don't think there's a basis for what I'm sure is going to be a focus of one of the issues here, and as to me unnecessarily multiplying proceedings. So in light of that suggestion, or in light of those comments, I would just respectfully submit that regarding her ongoing fee request, of which this was pro se as well, a pro se fee request in her opposition for order for show cause, and now she's retained counsel for this and the oral arguments, it's going to be a major theme here. I'm just highlighting that and establishing the posture of the case in light of those irregularities.
So what are you asking the court to do?
I'm just making a record.
Okay, all right. By way of the motion, the defendant seeks findings and orders of contempt against the plaintiff. The contempt power of the court is an extraordinary power, not to be taken lightly or to be exercised without considerable deliberation, intent, and purpose. The defendant specifically seeks jail time for plaintiff through his motion. In so doing, he asks the court to take rights of liberty from plaintiff, which is statutorily authorized as a sanction that is available to the court. As a result, in any proceeding in which the power of contempt is raised, it is imperative that the prerequisites of contempt findings are established. The order or judgment must be clear and unambiguous. The order must spell out details of complaints in clear, specific, and unambiguous terms so that the person will readily know exactly what duties or obligations are imposed upon him or her, and the violation must be intentional. A few preliminary observations. I conclude that these proceedings are civil in nature. These are not criminal contempt proceedings. I approach this from the standpoint of indirect civil contempt. Now, this still includes the same potential sanctions and penalties. I conclude that if I treated this as criminal contempt, which I'm not, plaintiff would have certain rights under the Fifth and Sixth Amendments, including the right to have counsel appointed. Even a civil contempt matter, it would be error for the court not to set this matter for an evidentiary hearing if I found a sufficient basis to issue an order to show cause. When considering sanctions, the alleged contemnor is entitled to present evidence through evidentiary proceedings, and the court is required to consider whether the appointment of counsel for the alleged contemnor is appropriate. We currently do have an evidentiary hearing that has been continued to September 4th. Now, just given my calendar, just so you're aware, I really don't have dates between now and then from an evidentiary hearing standpoint to schedule anything. So likely if I did set something, it would be scheduled contemporaneous with those proceedings. The focus of defendant's motion primarily is on two specific orders. The decree of divorce entered on July 21st, 2022 provides as follows. It is further worded that either party may enroll the children in an extracurricular activity on their residential time at their own expense or shared if agreed in writing, so long as it does not interfere with the other parent's residential time. If either party desires to enroll the children in an extracurricular activity that would interfere with the other party's residential time, then they shall first provide the other parent in writing with information pertaining to the activity, including the schedule, location, and cost. And the party wishing to enroll the child shall obtain in writing the other party's written permission to enroll the child. Whether the cost will be shared shall also be agreed in writing. A writing may include a mutually acknowledged email or text message. The order from the October 4, 2023 hearing entered on October 17, 2023 provides, in relevant part, the parent shall consult with their pediatrician rather than Google for health-related matters. If one of the parents cannot attend an appointment, then the attending parent shall request permission to video the doctor's recommendation so that the parents can have the same information in real time. First, I address the extracurricular activities provision in the decree. And I will have questions as we go throughout this for both parties. The extracurricular provision in the decree is a relatively common provision. It's not necessarily or particularly unique to this case. It's something that I do see from time to time in parenting agreements and decrees, stipulated decrees entered into by parties. The purpose is straightforward on its face. You cannot obligate the child to participate in events on the other parent's time. This has become a significant issue of discussion, both in the papers that have been filed and the text messages between the parties. And I understand the specific nature of what we're discussing, especially when we're talking about some type of regimented club activity. I'm very familiar with the rigidity that's been spoken of. That's the language that's used in the papers with respect to club type activities, which is part and parcel of the Learn to Skate hockey program. From club baseball to club hockey to club volleyball, I'm very familiar with how those work. And I understand intimately the intense time and dedication that's required to participate in some of those programs. I also, as a parent, understand the difference between, in distinguishing oftentimes between a Little League baller and a club baller in terms of their proficiency in different activities. We live in a time of specialization when it comes to athletics, and oftentimes children are buttonholed perhaps into a singular activity. I'm amazed, quite frankly, with all of the different activities that has been engaged in, from skating to jiu-jitsu to gymnastics. I saw text messages regarding soccer, and I do have questions about that. It's a challenge as a parent, and I understand the time commitment when you're discussing those activities and the type of involvement and a child's pursuit in those activities. But it's also not lost on me that I believe it's my understanding 5 years of age, will be 6 in November, and behind his sister. As I mentioned, she's participated in various different activities. I think I maybe even saw reference to ballet in some of the text messages. I don't know what her athletic proficiency is at her young age. However, in reading the text messages, you both appear to agree that she has some very natural or gifted athletic talents. I'm not here to judge that. I'm not here to offer any opinion whatsoever as to her participation really in any activity as part of today's proceedings. Those may be discussions as part of other proceedings. This is a contempt proceeding, and so I narrowly focus my attention to those specific items. The second primary focus relates to the medical care provision in a post-decree order. Now, this provision is unique. It's very specific to the history of this case. It's likely a provision that I have not seen in another case. But it makes sense with some of the things that have happened in your case, and so I understand why that became an order based on our prior proceedings and orders entered by the court. And the purpose, quite frankly, of this provision is highlighted by Plaintiff's Exhibit 7, which the defendant had transcribed, and it was also offered as an exhibit in writing. And it epitomizes the lack of trust between the two of you as parents. I watched the video and I understand how it brings everything in the past to the forefront, perhaps on both sides. Plaintiff appears in the video asking some questions repeatedly, as if not satisfied with the initial answer that was given. It got to the point where to become somewhat agitated with the discussion. Again, although not germane to these contempt proceedings, it appeared that suffered some type of but because of the history in this matter and concerns and allegations regarding sexual abuse, any time a child now experiences anything like this, suspicions become automatic, and that rises perhaps on both sides. Thus, we have a provision that mandates the recording of a doctor's recommendations so both parties are present or able to be present for those recommendations. So that's the nature of that provision, which is very unique. Third, there also is a request for contempt as it relates to allegations of denied custodial time. I emphasize again that the issues before me today are not about modifications or adjustments or refinements to the existing orders. Although such refinements may be appropriate and may be something that should be considered by the parties together, that's not my focus today. Rather, my focus is the exercise of the court's extraordinary contempt powers. So that I have an understanding, however, as to how these provisions have functioned, I do have questions regarding each of these areas, and I'll start with the extracurricular activities provision. And I start by noting that, well, let me ask before I get to that. The sense I get is that neither party has been asked to contribute financially to, or has contributed financially to any activity that you didn't concur or agree to contribute to. Is that a correct assessment?
That's incorrect, Your Honor.
So have you been forced to pay amounts that?
I have not been forced, that the request was made at the outset in July of 2022 regarding Learn to Skate.
Okay, and did you actually pay?
I did not actually pay, but the
Okay.
request was made.
Okay. Beyond that, has there been any request for payment of any activity as well that was younger and just starting, and there's been reference to that? Any
No, Your Honor.
payments? Since the entry of the decree, have the two of you agreed on participation in any extracurricular activity? I did see references to soccer. Was there an agreement? Did she play soccer? I didn't see a lot of text messages because that wasn't the focus, but did she participate in soccer?
Yes, Your Honor.
And that was agreed to?
Yes, Your Honor.
And you each, I assume, equally paid then towards that expense?
I'm not sure that I paid anything for that, Your Honor. I don't remember.
Okay. Was it just one season?
She was in for 4 seasons.
Oh, 4 seasons. So she played quite a bit of
She
soccer.
started when she was 3, 2.5.
Okay, you acknowledge that?
It was a drop-in style schedule because of her age. So I'm not sure. I don't recall how many
Okay.
seasons it was.
But did they have games on set days, generally on Saturdays?
There were no games. It was just a bunch of 3-year-olds or 2-year-olds or whatever she was at the time, and a ball, and it was instructional and drop-in. So there's very, very open circuit in its design.
So it really wasn't a team activity?
It was not a team activity. It was instruction with multiple balls and multiple instructors, and they were just learning. It was similar to learn to skate, but without any of the rigidity.
Okay, do you agree with that, Mom?
It was scheduled for every Saturday morning. So it was a scheduled thing. It wasn't just drop-in.
There were no alternate days?
No, unless she missed and I had a conversation with the coach would allow me to come a different day, or allow her to come a different day.
And generally, did you both make sure she attended on those regular days, regardless of the day?
Yeah, she always went on my days, and Cody did the best he could on his days.
Okay. Has she participated in any other team sports?
She was accepted to gymnastics. We had the conversation and Cody said no, so we didn't put her on the gymnastics team.
Okay, so no other team sports?
I don't think the soccer, again, I just don't think it was a team-based thing. It was just instructional. It was like this.
Right, well, I guess my question is, has she ever participated in a team sport?
No,
Okay.
not to my knowledge.
Well, and that becomes a question, again, not as part of the contempt proceedings, from a practical standpoint. Does this type of provision effectively disqualify not only both of your children from ever participating in a team sport? There is a unique aspect to your custody schedule. As much as there is some level of consistency, and it's easy to read the schedule over time, there's no consistency as it relates to each party having set specific days on a regular basis where you could schedule an activity and know that a child is going to be in your custody on that day that would allow you to have the child participate in, for example, a team sport. Again, that's not my focus today. That's perhaps for another time. But it is an invitation for you and at some point the court to explore parallel parenting versus co-parenting, because that's part of what I'm reading into much of the discussion in your messages between the two of you. Is this matter devolving into a parallel parenting type arrangement? That's something that you drive, not necessarily the court. That's driven by you. But it is unlikely with any regimented activity other than drop-in activities that you could successfully coordinate a child's participation in an activity on your set specific custody days, because those change. The focus, much of our focus appears to be on skating or hockey and jiu-jitsu. The first communication appears to be the day after the entry of the decree on July 22nd, 2022. With respect to learn to skate, plaintiff texted defendant, quote, "I will be signing her up for that. Can you pay half?" Close quote. Defendant liked, that's the text message that I gleaned, the message the same morning. Now, I don't know what that meant, but it was liked as to that specific message which said, "I will be signing her up for that. Can you pay for half?" On the same day, plaintiff asked defendant about signing soccer. Defendant messaged that he's not sure if he can facilitate all of the events for all of his children. Quote, "Soccer probably, but skate probably not," close quote. The plaintiff then volunteered to pay for Learn to Skate on her own and stated, quote, "I will facilitate transportation and I will pay for it. I ask you if Learn to Skate lands on your day that you either facilitate her to it or you allow me to facilitate her to it, because if she misses more than 2 classes, they will take her out of the program," close quote. She then reiterated that has wanted to do this for more than 2 years and quote, "I do not want to keep that from her. She deserves it." With respect to the issue of learn to skate and hockey in general, plaintiff alleged that defendant has not actually taken a learn to skate class, I believe, since the end of 2023. Is that accurate? Is that accurate?
That is not accurate, Your Honor. That's
So-
what she said, but that's not the case.
Right, so since the end of 2023, there have been occasions when you believe you have taken her to learn to skate program.
There's been the ask from her and I've denied it.
Oh, no, I know there's been asked. My question is, have you actually taken her to learn to skate on your custodial time? I know there have been asks. There have been,
Yes.
that's woven throughout those text messages.
That's
Have you-
correct, yes.
Have you ever taken her?
Since December of 2023, I don't believe that I have.
Okay.
You know, I have to, because I may be conflating 2024 and 2023. I have a timeline. May I look at to refresh my memory?
You may look at that.
Okay. Court's indulgence.
And I just note, it does appear that from time to time, the custody schedule has been shifted. There have been accommodations so that plaintiff could take those activities.
It looks like that is an accurate statement to say that the requests have been made and I have not since December of 2023, since I started the right line objecting.
Okay. The, it's my understanding from reading the papers, and this was something that was mentioned by the defendant in his papers, that due to the rigidity of the program, dropped if she fails to participate on those days that fall during his custodial time. And that's even referenced by plaintiff in some of her messages. And it was even highlighted, the program itself, if you go onto the internet, has those type of limitations. And so it does appear to be supported by requirements posted online. My question is there any type of workaround in that regard?
Yeah, when I wrote that text, I had just started her in the program. I was fairly new, but she's missed a lot more than 2 classes per her sessions. She's been in 6 sessions, and they've passed her every time, and they've taken her up to the next session. So I'm finding that it's more based on your skill set and your skill level than your participation. So if she passes her skill set and her checkoffs, then she just goes into the next. It doesn't matter what she misses.
They will advance her.
Yes.
Okay. Is that your understanding, sir?
That's not my understanding. That's my understanding of what her new argument has been in her opposition since I filed the motion for order for show cause. But historically, I mean, even as, and I appreciate the fact that the court has done a detailed read of these, but just last month, she asked me to return early from a vacation to take on to her very first class. And I want to be clear, I'm not overall objecting to learn to skate. Hockey can be a good thing, but due to the level of conflict in the prior filings, like her January 15th, 2024 filing, where she directly connects my ability to parent to my ability to do extracurriculars and participate in the broad scope of activities that she schedules for the child, which some of them or only one of them I've objected to. That's where the issue is.
Well, but to the point of her participation, are you aware of any situation where she has been denied advancement due to missing too many classes?
It's been represented to me that way over and over and over, but I'm not aware.
You're not aware that it's actually happened?
Correct.
Okay. All right, with respect to jujitsu, which has been described more as a drop-in activity, it's my understanding this is not a team event. These are individual sessions that you just drop in.
They're individual sessions. They do occur on like Tuesdays and Thursdays, but from the outset, my initial, I pursued this under the permissive clause as I understood it, because it had no impingement upon her residential time in any way, and I specified that in my text message, that essentially this will never impact your custody, so I'm signing her up for that. And it's like a gym membership. It's like LVAC. You come whenever you want inside of those hours.
And how regular has that's been? at
She
jujitsu?
attends when she can, so it's not regular. It's because of the rotating schedule, it can't be regular, but it's kind of like you go home, you touch home base, you get refreshed, and then we go about our normal schedule.
When the days fall on your custodial time, your residential time, does
Yes,
on Tuesdays and Thursdays? So if you have Tuesday and Thursday, she attends jujitsu.
that's correct, unless it conflicts with the other schedules in the household. Generally speaking, yes, we drop in.
Generally, she does.
Yes.
Okay. Has plaintiff, have you taken her to jujitsu during your residential time? Okay. Does her participation impact her advancement? I'm assuming there is some type of progress that she achieves based on the number of classes or her proficiency. Is that part of the jujitsu program, or does that even matter?
There is, she can earn stripes based on the hours that she attends, but it's all based on her skill level. So there's no obligation. If she goes and attends and she remembers her technique, but there's no set, the way they do it is if she's showing the proficiency based on however often she's coming and her skill level, then they will give her a stripe. But there's no team aspect to that, if that makes sense. Some martial arts programs, they'll do a belt test, like you have to be here. This is not like that in any sense. She's a white belt getting one stripe. If the teacher notices her do a good technique, she gets the stripe right there on the spot essentially.
It's not about putting in a certain number of hours, it's more proficiency.
Yes, yeah, with Brazilian Jiu-Jitsu, it's 100% proficiency.
And does she enjoy participating?
She absolutely loves it, but that brings on the question that you're asking. Well, I'll let you lead the situation.
Is she disappointed if she doesn't attend jujitsu when she's with the plaintiff?
No, not to my knowledge. It's there.
But
Whatever
could that
she's-
create disappointment because it's an activity she's familiar with attending during your residential time?
No, what I think I'm touching on is the anti-disparagement clause, because when she will say she doesn't want to go, but whenever we get there, she has a lot of fun. And I'm aware, I think I can tell where that resistance is coming from, if
Right.
that makes sense.
Well, and listen, I think apart from the contempt, I recognize there's a larger issue that we're discussing that has been somewhat woven into the papers that includes Dr. Berquist's involvement. Now, to be clear, Dr. Berquist's recommendations, her involvement has not become part of the orders of the court in terms of the court having received her testimony, because we're still waiting for her to testify. It's my understanding that that's the reason that the evidentiary hearing unfortunately was continued because of her unavailability. So I still haven't received her testimony, and part of that that's been discussed in the papers relates to appointment perhaps in being able to or not being able to participate in different activities. Both of you, to be clear for the record, have enrolled in particular activities without the consent of the other parent. The nature of the activities, I'm in tune with how they're different, the drop-in versus the rigid programs. But again, this is part and parcel of the type of custody schedule that you have, is that her participation is limited based on the fact that your residential time shifts and changes, and there are no set days. But to be clear, there are activities that you have each enrolled her in that involve potential participation on days that from a residential standpoint belong to the other party. And the larger issue is, do you want to be notified in case you desire to participate in a particular activity? And that was somewhat, as I read into the communications, because the jiu-jitsu text message from defendant to plaintiff was, here's the schedule, it's every Tuesday and Thursday. If you want to take her, basically please do so, I'm paraphrasing. But also said, don't feel committed or obligated to do that during your residential time. It was more information, here it is, if you can, great. If you can't, then it's understood. So a lot of this really is the communication that's going on between the two of you. And I think there's something certainly that is positive from relaying the information and inviting your participation. Whether it's mom's participation in jiu-jitsu or dad's participation in hockey, we've created this situation where she understands she's participating in one with dad and perhaps one with mom. And from her standpoint, she probably would love to have mom participate in jiu-jitsu and dad to participate in hockey. But we're not there yet. Listen, I saw the photos that you exchanged with each other, from the hockey photos to her jiu-jitsu uniform, just absolutely wonderful, awesome. You're exchanging that. I'm assuming you want to receive that information and you're delighted when you receive that communication. That's your daughter. That's awesome. And it was heartwarming to see that, and I'm assuming that's truly what you want. But again, we're starting down this path of parallel parenting. And that's a different issue, to be clear. It's a different issue. I'm here for enforcement, but I think these are important things for the two of you to continue to have discussions. And sometimes I'll tell you, your discussions are great. I haven't seen them all, but sometimes you do communicate to a level that I don't see between a lot of parents. You develop these transfer notes where you exchange information, detailed information about their morning, their day. And at times I think, boy, you are good communicators, and then it's completely the opposite. And you've got years ahead, but you have beautiful children, and I know you both deeply love your children. But that is the paradigm you're somewhat establishing. Are we setting up a paradigm in which you're encouraged not to notify the other parent of the child's involvement in an activity for fear that you're going to be accused of violating this provision? In other words, don't even consider letting the other parent know of an activity or their ability to just show up and, hey, I'm here to practice, I'm here at a game. Is this where we're headed? With respect to the medical care aspect, I want to make sure I have an understanding of the timeline of events. There were two specific events that were discussed and noted in the papers. And the sense I had from reviewing the messages were that these were ER visits. Is that correct? Did I read that correctly? They were not pre-established wellness type appointments with a doctor. Did I read that correctly?
That's correct, but there were bleed overs for follow-ups where there's some overlap there. But yes, the count 3, the August 28th, 2024 incident, that was an ER, and the March 30th, the count 4 was at that very same ER. So if that's what the ask is, then yes, those were ER.
They were both emergency room visits. Do you acknowledge that?
Yes.
So, and from the timeline, because the provision is very specific, that's in the order. If one of the parents cannot attend an appointment, then the attending parent shall request permission to video the doctor's recommendation so that the parents can have the same information in real time. So going through those visits, they weren't necessarily regular appointments, but so walk me through what happens when you show up for this visit. Let's start with the first visit.
The first visit, usually with the ER, you have to check in at the front, and then you go into intake, and so usually a nurse will greet you, take basic stats like saturation, blood pressure, temperature, and then the doctor is notified. They usually find a room for you unless they do just a triage in the hallway, so usually we'll go back into the room in these cases. And then the doctor comes in and says, what they're going to do, and then they'll run tests, and then they'll come back at the very end with your discharge what they think's going on and any test results that they received. And that's usually, for the past few years, that's usually when Mr. Campbell wants me to FaceTime, is when the doctor comes in at the end with the discharge papers, telling us what to do, what they thought of the situation, and care to the future, like if we need to do a follow-up.
So that's your summary of what happens generally, but going back to the August 28, 2024 visit, do you recall specifically what happened on that occasion?
It was a lot of the similar, so, I know that visit was a little different because Mr. was in communications with one of the nurses, so he had called down there. And, the nurse notified me and came in the room and said, your ex-husband is on his way or here, I can't remember which one. And is it okay if he comes in? And I said, yes, absolutely. And then, they ran some tests, and Mr. came in towards the later, and that was kind of it with that one. That was the only difference that I noticed in that ER visit compared to others.
So had the doctor come in prior to any arrival by Mr. Have you communicated with the doctor prior to the doctor issuing recommendations?
No, just that the doctor came in with several nurses to do some tests. So it was kind of a group of them walked in to do, as two nurses and the doctor came in to do some tests. But I had really very little communication with the doctor other than to be asked, you know, when it was like kind of basic questions about like being allergic to anything and stuff like that, but not really a conversation on what experiencing at that particular visit that was centered to that. That would be towards the end.
Did he make any recommendations at that time?
It was actually a she, and she did not. She said she touched her stomach and they did a look exam, and then she told the nurses basically what tests to run and what they were gonna do. They ran the tests, and then she just said, you know, wait, we'll let you know the test results, and we'll come back in and we'll basically let you know what's going on after we kind of do the first part of it.
And the March 23rd, 2025 visit?
March 23rd. I don't have what was that follow-up? I don't remember.
Can I pull the exhibit so she can refresh your
You can
recollection
pull
about
that.
that? Can I also ask a follow-up question to what you just asked her? Just a very,
That's fine.
when you were just discussing now that the doctor came in with a couple of nurses, how long were they in the room?
Probably about, I would say 2 to 3 minutes. It was very quick. They just felt her tummy. They did a visual. They did a swab really fast, and then they left.
It's your testimony the doctor did not make recommendations at that time.
That's correct. Yeah, they were just at the beginning of kind of doing an evaluation.
And then when the doctor did make recommendations, was Mr. present at that time?
Yes, Mr. was present at that time.
Okay. All right, so March 23rd, 2025.
date again, Your Honor, of that visit?
It was March 23rd, I believe, if I have the date written correctly, March 23rd, 2005. That was called for.
I found it, sir.
Okay,
That March 23rd was when I took the doctor.
okay, that was Zeke. Okay.
Yeah, it was, he had a cough. I texted, that I was taking the doctor, and he said why, and I said, cause he had a cough, but it was kind of in his chest. On breathing treatments and albuterol, and he's had respiratory stuff off and on. So it just sounded like it was in his chest, so I picked him up from, he had a pretty deep cough, and that's when I took him in. They did a chest x-ray on that one because the doctor even thought that it was in his lungs, and she was afraid it was pneumonia. So I said it was okay at her recommendations to do a chest x-ray, and then that was for that visit.
Okay.
So it kind of went to the same, I always try to go to Sky Canyon ER because it's really close to both of our houses. And they kind of just have the same intake process. You check in, you do the stats at the triage, and then they get the chief complaint, they run the tests, and then the doctor comes in with the discharge and what they think that we should do as treatment or follow-up.
Different doctor though?
That one was a different doctor, yeah. That was not a female doctor, that was a male doctor, but it was the same nurse.
Okay. Mr. Different understanding on your end as to how that played out.
Yes, Your Honor, completely. Do you want me to stand up?
No, you can remain.
So according to the records, which are certified records, that first of all, backing up, the history of this incident is relevant, so I would like to narrate what the history. So regarding count 3, the 8/28/2024, which was about 8 months ago, that morning.
Very briefly touch on the final issue, which relates to the missed visitation time. The sense I get from everything I've read is that over time, this has somewhat been, in terms of exchanging a calendar, that's been a routine, regular event, and the defendant provides plaintiff with the duty calendar, the drill duty calendar, and that's been commonplace. With respect to the dates that were referenced in that calendar, we're talking about one specific date and missed visitation time. Were the other duty dates fulfilled, or that were on those calendars that were exchanged? Were there any that were canceled or missed?
Can you restate the question, Your Honor?
So the calendars that I viewed that you provided to the plaintiff set forth various dates, scheduled training dates. Were those dates actually fulfilled? Did they go forward and you participated in those training dates?
That's not it changes all the time, I can't remember.
Okay, so there may have been some that were canceled, or?
There's some that are canceled they might shift left or right as you're looking at the calendar. There might be time shifts, it might not be 9 to 5. It's all predicated on the need of the pilots on whether they need to fly nights or missions or whatever. I can't remember if during that entire 365-day period there was any shift in a given month.
There is one referenced as annual training. Are they all considered annual trainings, or is there one out of the year that's the annual training?
It is the annual training, and there's a history of using the annual training period. During the CPS issue was nested while I was in an annual training. I had just left, and there was a lot of run-up communication. Are you still going? Are you still going? Things like that in text messages. And the day I left was the day the CPS was called. And that investigation started, and I wasn't let know about it until a few weeks later, and I had to come back. But with a history of the case, shows that there's a lot of communication whenever it suits her needs. But whenever this was a like 3-week block of training, we normally go out of town and do something. And because of my transitional status, I'm not in the communication loop anymore. So yeah, there was a miscommunication, but that miscommunication doesn't supersede the custodial schedule is my position. And there was multiple subsequent attempts to try to cure it, even while this motion was pending. Hey, just we can just give the kids back their 4.5 hours back with dad. And I think you saw messages to that effect. And then even over Easter, there was a similar issue where it made sense to cure the issue, but it would have been like 14 hours because at 7 p.m. the kids were going to go back to her house, and at 9 p.m. over Easter, and this was through text message, they were going to go back at 9 in the morning on Easter. I was going to pick them up. So to get rid of all of that, just to create a through line, just allow the kids to be with me. And I know it's like 14 hours or something, but that will cure this, and we can eliminate and simplify the issues on the OSC. She rejected that.
Has there ever been an annual training that hasn't taken place?
No.
It's always happened.
It's always, it might shift left or right, but it has to happen because we have minimum training days that we have to do.
So I know, and you've mentioned that leading up to any of these trainings, annual or not, there generally has been some communication.
There's communication.
But there was no communication on either side
Correct.
as it relates to this annual training, other than
The day
the
of.
schedule that was provided to the plaintiff saying this is an annual training day, which has taken place, you admit,
Yes,
every year
yes, it's taking place
without
every year.
fail.
And there's that clause in there that says they're subject to change at no notice, essentially.
And you acknowledge in your papers, though, that it wasn't as though you communicated with plaintiff to let her know it's not happening.
I did not communicate in advance, but as
So
of-
the only information she had was a calendar that said defendant's gonna be in annual training during this time.
that is correct.
I guess my question for the plaintiff, because the point made by the defendant, and we're talking about indirect civil contempt, which is coercive in nature. The easiest solution to all of this, and that's something that Mr. Campbell touched on, is just make up the 4.5 hours. That's the purpose of contempt. If that had been made up, it's not even an issue of discussion. Now, listen, I think there's been a lack of communication. The only communication, as Mr. Campbell has acknowledged, was providing the calendar. So, is there a reason not just to make up the 4.5 hours and at least that brings to a close that issue?
So, on the question
even-
of whether or not, I mean, they're two separate issues, right? One is, can you make up his 4.5 hours, or is what is contempt? And
Listen, I completely agree, but
Okay.
you just removed that.
contempt
There's a lot
requires
to be decided in
disobedience to a
terms of
lawful
it.
order, and I think you just laid out why this is not disobedience of a lawful order. So that's a separate question that, regarding the making up of the 4.5
Well,
hours.
listen, yeah, there's a lack of communication on this specific issue. I will say this, and I'm going to be issuing a written. There was a fundamental lack of communication on this issue, and the only communication, as I've touched on, is a calendar saying, here are my dates, which includes an annual training, and that's the only communication. There had been communication regarding some of these other dates, but I don't necessarily, this is one of the accounts of contempt that I don't necessarily fault the plaintiff for the lack of communication, because there was a lack of communication on both sides. The only documented communication was a calendar that specifically stated that the defendant was going to be unavailable on that date, and there was never a word said. And so I agree that the issue of contempt is weak in that regard, but it's even weaker because without a doubt, defendant was available, plaintiff had the children, and the easy fix to this, to remove it from the court's plate and remove it from court itself, is here's 4.5 hours, and we're done on that issue. It's almost a side issue to me. The other issues, I've spent more time, and I don't want to spend too much time on this issue because I don't know that it's as significant, and it could have easily been cured, even though I agree, I don't know that it's a matter of contempt. I agree with Ms. Wilson in that regard. We've had some lengthy discussion here. I appreciate the time we've spent together. And again, in terms of the recording and dissemination of these proceedings, I trust that my orders will be adhered to in terms of making sure that those sensitive items, specifically related to the children, will not be disseminated. That includes whether it's being recorded now or the dissemination of those discussions by way of what's been recorded on jazz. The matter will be under advisement, and I know you're ready. Thank you for your appearances.
Thank you, Your Honor.